Thought Peter said he was running the meeting, but maybe he only meant his part. So I'm going to get started and introduce Barbara. Pete, period. Sorry for the mix-up.
That's okay, Sarah. You can introduce Barbara.
Good
That's good.
afternoon. It is November 18th, and you are here at the Office of Special Education Services information session for special education. I apologize for the delay. I had a little bit of a mix-up, but we are delighted to bring you Barbara Drayton, and she is going to talk with us today about legal updates. So Barbara, if you're ready to share your screen, we are happy to welcome you here this morning. And unmute your microphone. And I can help in any way you'd like. One thing we can do while we're getting set up is to remind you to please mute your microphone so that we don't have any feedback or carryover from where you are. That always helps. And in your Google folder, you have today's slide deck and a new organizational chart for the Office of Special Education Services. And you know, I put that in an email and I'm wondering if I hit the send button. Do you ever do that? Put things and they end up in your drafts folder? Let me look. There it is. And momentarily you'll be getting an email. And I'm going to step off camera for just a minute and see if I can contact Barbara.
Barbara's here.
Hey, Barbara, if you want to go ahead and share your screen, you can start your presentation.
See if this works better than it did on Friday. Can you see the presentation?
We can see it. If you want to just put it in a slideshow mode so it's full screen, that would be great.
Okay. Good afternoon, everyone. It's been quite an afternoon if anybody's been watching their news feed. If not, don't go watch them now. Some of you may have seen some of these slides from the presentation that I did at SCASA with regard to some of the guidance, court cases, OCR decisions that have come out during 2025, but I have updated the presentation with any information that I'm aware of that has come out in the last couple of months to make sure that you have some of the latest and greatest news for us. If my slides will move right now, they are not advancing. Okay, of course, and I don't know, Peter, if you're going to provide any more information on this later, so I won't steal your thunder, but I know there was the press release from today about changes at the U.S. Department of Education and the unveiling of the first part of the plan to move various offices within the Department of Education. If you already have that built into your presentation, Peter, please let me know and I will stop right now.
No. Go ahead, please.
Okay, because I think they may be doing a press conference later. But the pieces I know in the last hour that are out there as far as what's been revealed is with regard to movement of the Office of Elementary and Secondary Education to the Department of Labor. So anything basically dealing with post-secondary education is slated to go to the Department of Labor. Those, anything with regard to Indian education going to the Department of Interior, and the foreign language and international education going to the U.S. Department of State. As of an hour ago, there was nothing released with regard to OSERS. You know, word on the street is that that will be released between now and December 9th. And Peter, if you saw something else with regard to OSEP and OCR in the last hour, or something comes out in this presentation, I'm sure you will update us. But those are the parts they were done. My understanding is through agreements with those departments, because by federal law, it really says because the U.S. Department of Ed was created by Congress, that Congress is the only body that should be able to dismantle the U.S. Department of Ed. And this is being done through interagency agreements with where the various offices will move. So even though this is a plan that's being unveiled officially today, as everyone fully expects that there will be some lawsuits that'll be filed, and we'll just see whether there'll be a stay while these things go through the courts, and it'll probably be pretty quickly, but we'll just have to stay tuned. Okay, and that's as much as I know about that right now. So moving back into court cases and other updates, because regardless of where special ed lands at the federal level, if it stays at the federal level, the information that I'm going to provide today will still be the same, because a lot of these will deal with court cases or decisions that have been made from the federal level. So until something is actually overturned or there's a change in IDEA or Section 504 or the ADA, everything will still be applicable regardless of where special ed programs are housed. Of course, you've probably heard a lot about the case that came out on June 12th. This one definitely would remain the same because if this case is out of the U.S. Supreme Court. And so again, unless Section 504 or the ADA changes with regard to the federal law, this is the case, this is the ruling that applies. It's the law of the land at this point. And of course, this one deals with a student who is eligible under the IDEA, but as we've been reminded a lot by the federal courts in the last few years, there's nothing that says if a child is covered under the IDEA, that the parents can't choose to pursue their options or their remedies under Section 504 and the ADA. Because if that student has an IEP, they do have all of the rights and protections that are afforded under the ADA and Section 504 as well. In summary, because a lot of you probably heard about this case already at this point over the last 4 months, but student who had a rare form of epilepsy, severe limitations on physical and cognitive functioning. Because of the seizure activity, this child could not participate in school prior to 12 o'clock. But by noon, usually the seizures had subsided enough that that child could receive educational services and could receive a FAPE with those services. It wasn't a fact that the child couldn't benefit from education. It was more about when the education needed to be provided and what were reasonable accommodations. In the previous school district, they accommodated the child's needs and built a school day around the child's needs. So the child's school day went from noon until 6 p.m. But then the parents moved to Minnesota And I think you can pretty much see how it played out. They moved to another state, a new district. They said, you know, our child, the school day was 12 noon to 6 p.m. The new district was like, well, sounds like you need to turn that moving van around and go back from whence you came, because we will start at 12, but the day is, we'll do 4.25 hours of instruction. That's going to be the end of the day. We're not considering the 6.5 hours. The parents were, but our child is entitled to the same length of school day as non-disabled students. And it's not about what's convenient for the district or what you provide to everyone else. And when their school day ends, this is about developing a program that meets our child's individual needs. They first pursued the IDEA claim based on the school district's failure to provide a 6.5 hour day for the child. And they won compensatory services under the IDEA claim. And the court, and it was ordered that they were going to have to extend the child's instruction into the evening, because the child could receive the instruction, could benefit from the instruction. It was just changing that child's hours of need. So for those who look at, okay, if a kid it has these issues, we're going to do medical homebound and 1 hour a day or 1.25 hours a day. I very strongly encourage you to look at this decision from the U.S. Supreme Court with regard to shortening the child's day and making sure that you're looking at each child's needs on an individual basis. After they were successful on the IDEA claim, the parents brought suit under the ADA and 504. And they were requesting a permanent injunction so that the district would not revert to the practices of the shortened day for their child or for other children in a similar situation. They wanted reimbursement for their court costs and compensatory damages. The school district, of course, said, wait a minute. You know, first they were like, you're already successful under IDEA. They shouldn't be able to bring these claims now, same claims, same facts under 504 and the ADA. But of course, from Fry as well as Perez, the U.S. Supreme Court has been very clear that you can do both. Same set of facts, and you have two avenues as far as pleading your child's case. The difference is that 504 and the ADA, by going that route, the parents can seek compensatory damages, which are not available under the IDEA. So in this particular case, when it got to the federal court, they said, with the federal district court, they said, wait a minute, you have to show that the conduct of the school district rose to the level of bad faith or gross misconduct in order to succeed on your claim with the ADA and 504. And that's what the Eighth Circuit was saying, and that there wasn't enough fact there to rise to that level. Well, this caused the Supreme Court then to look at that standard, and they said, well, wait a minute. Bad faith or gross misconduct, if this was the public library or another state agency or public entity, that's not the standard. The standard is deliberate indifference, which is a lower standard to seek damages. And the U.S. Supreme Court, with the district fighting this case, it forced the U.S. Supreme Court to look at the standard to determine whether the standard that parents of students with disabilities had to meet, whether it was fair. There was a previous case that had gone through the federal courts that set that standard, but the U.S. Supreme Court said after that case, IDEA was amended back in 2006, and then the regs were changed, and the provision was put in that says, notwithstanding any other laws, I mean, you could have your claims. So they said there was nothing that would prevent the family from going through both avenues, and that it was unfair to set a higher standard for parents of children with disabilities. So they said the standard now is not bad faith or gross misjudgment when you're bringing that claim under 504 and the ADA, but rather deliberate indifference, which is a lower standard than bad faith or gross negligence. And it was a 9-0 ruling back in June. So all of the 9 justices, were in sync with regard to lowering the standard. This Barnes case is out of the Fourth Circuit, which South Carolina is in the Fourth Circuit with regard to the courts of appeal. Here, this was a situation where it was a dispute about whether the child has a learning disability. And in this particular case, it started with the child being in 2nd grade. And the parent said, "Oh, our poor baby's grades have gone down." Even though there was a decline in scores from assessments, district and statewide assessments, the child was still performing in the average range for same age peers. But the parent said, "Oh no, it must be the adverse effects of his dyslexia, and that is affecting his reading and writing, as well as his ADHD affecting his ability to learn." Again, there was no dispute that his scores were lower than the previous year. So the dispute became what was the impact of the diagnoses upon the child's ability to learn. And so they looked at everything, and in this case, the federal court said, yes, there is evidence that this 9-year-old boy has dyslexia and ADHD. That's prong 1. But now you have to look at prong 2 as to whether the student needs the special education and related services to receive a FAPE and to benefit from his educational program. And that's where the Fourth Circuit Court of Appeals said, again, every child who has a disability doesn't need special education related services. But of course, it all hinged on the data. The parents will show their argument, as we see in most of cases where someone is pleading for a specific methodology. They said, yes, when the child started showing growth and progress, the parent said, it's because we attained a private tutor who uses Orton Gillingham. The district, of course, said, no, it's because of the instruction we're providing. And in this particular case, the court said, well, it just wasn't clear. So in this case, tie went to the school district. So yes, they said, we believe the child has a disability, but no, we do not believe that he needs special ed related services, specifically with regard to instruction using Orton Gillingham. This next case is one that was against the Oregon Department of Education. It's a state case, but because it involved a Department of Education, I wanted to include it. And it also deals with shortened school days. And we know that that pretty much affects districts all across the country. But this started with regard to a class action lawsuit that was filed in Oregon back in 2019. And they were saying that students as young as 5 and 6 years old were either being separated from their peers, they were having limited educational opportunities, or that the districts weren't appropriately addressing negative behaviors and things that were causing the children to be excluded from programs with their non-disabled peers. They brought this particular lawsuit under the IDEA, 504, and the ADA. And they gave facts and they talked a lot about students with autism, with emotional disturbance, and with communication impairments, and that a lot of the kids, their placements were being changed, and that they were only receiving as little as 5 to 10 hours of instruction per week, especially when they were either at school and shortening the day, or when they were being moved to home-based placements, that across the state, districts were only providing 5 to 10 hours of instruction versus a full day of instruction. This was brought up. Oregon acknowledged they had a problem. The legislature saw this as a big problem with abbreviated school days all across the state for students with disabilities. So they ended up introducing legislation that required the Oregon Department of Education to collect data, to do training across the state, and to discourage the shortened school day. And then the court threw out the lawsuit. They said, hey, it's finished. The state took action, but then the groups that brought the lawsuit came back and said, no, no, no. The case was thrown out prematurely. Even though the state enacted legislation discouraging the use of shortened days in public schools, the state doesn't have enough data to show what they've done and whether it's been successful. Just because they say that they put in place these policies and procedures, it's the practices that are still a problem. And we don't have enough data to show the effectiveness of the policies and procedures on changing the practices. The sponsor of the bill in Oregon spoke with different people in the field, including parents. And some of the parents said, this is the best thing that's ever happened. My child is now being able to stay in school or receiving more instruction, even if his or her placement has changed. But then they also heard from some other parents that said, hey, yeah, that's what it says on paper, but nothing's changed. And they even spoke with some folks who worked in the school system and said, no, we're still being told when we go into the IEP meetings that we're going to shorten this child's day and this is the amount of services we're going to provide. So the original sponsor of the bill ended up siding with the folks who filed the lawsuit and encouraged the court to bring the lawsuit back until they had sufficient data to show that the work that the Oregon Department of Education was doing was actually effectively reducing the use of shortened school days. This case with Rankin, this was the district placing a child in a residential treatment facility because of the significant behaviors. He was smearing fecal matter, engaging in self-harm. He had obsessive compulsive tendencies. He would run when he was overstimulated or overwhelmed. So there's no doubt as to how the child ended up in the RTF in Jackson, Mississippi. And we know if a district places, the district is still responsible for providing the child with faith. Well, just because you put the child in a residential treatment facility, again, it's the district's responsibility to make sure that the program is still appropriate and it's reducing, replacing, or eliminating the negative behaviors that led to such a significant change of placement. In this case, actually, the residential treatment facility was reporting that the student was still being unmanageable, disruptive. He was running, but the reason they chose this particular RTF was because of the high fence that was around. So even if he ran, he couldn't get outside of the premises. But when they looked at the data, from the time that he was 7, he was functioning at about a kindergarten level. But well, actually, he was at a first grade level at age 7, but at age 14, he was at a kindergarten level. So he'd actually regressed based on the data in the 7 years that he'd been at the RTF. But the information that was being shared with the parents was that the child was making progress. Well, finally, the facility during COVID said his behaviors became so significant that even the facility was saying this is not an appropriate place for him. He is not making progress. He's still presenting a danger. He is pulling down his pants. It's some of it. When you get the slides, or if you look at the slides, I don't have to repeat some of the behaviors this child was engaging in. So they called a meeting, got the parent in, and even though they've been telling the parent how wonderful this placement was for him previously, now they had to start discussing removing him from the facility. Well, the plan with removing him from the facility was not to take him to another facility, but to bring him back to his home district. The parent said, wait a minute. When we've had these discussions before, we were, of course, hoping he would come home, but you all said I would be involved in any discussions. And we talked about the fact that when he came home, we would start with a much smaller environment and we would really have some meaningful participation in this process. Well, the principal said, tough. He's leaving the facility. He's coming back. He's going to his home school. The mom was like, no, he needs a much smaller environment. All of the reasons for which you all said he needed to go to an RTF, the same problems are going to exist when you bring him back to his home school. The principal said, too bad, too sad. Here are your procedural safeguards. Here's your prior written notice. You don't like it. you can file a complaint with Mississippi Department of Education. Well, the parents then requested a due process hearing. And of course, there wasn't anything to show that the district had any real plan for providing this child of faith by bringing him back to the school district. The school district actually pled that this is not a change in placement, it's a change in location. Of course, that didn't fly. And RTF and the regular homeschool are not by any stretch of the imagination at the same point on the continuum of placement. But the court also said the mom couldn't show whether the smaller school she wanted or the larger school, which is where it's home program, that one was going to be worse, better or worse than the other. So the mom lost on the issue of wanting a particular smaller school, but she won on the claim that the district was not offering a free appropriate public education by bringing him back home. So then the parent went into federal court seeking attorney fees, because that's the thing. The hearing officer can say if someone substantially prevails so that they can then take that into federal court and ask for attorney fees. The district said, well, mom didn't win on all the issues, she shouldn't get attorney fees. But the court said, no, she didn't win on all issues, but the issues that she won on were significant enough that she should be awarded attorney fees. So the point there is that a parent doesn't have to win on every issue in a due process hearing to end up being determined to qualify for attorney fees if they go through the hearing. Graduation with a high school diploma does not always equal a free appropriate public education. That is one of the main points in this particular Sixth Circuit Federal Court case. Here, the student had dyslexia. It was in the news a lot at the beginning of this year because the student had graduated with a 3.4 GPA, but he still was unable to read. And people were like, how could that possibly happen? Usually, once a child gets a high school diploma, districts are like, we're done with faith. He got a high school diploma. That's it. The premise of this case is no, that is not always true, especially when a kid graduates with a regular high school diploma and still can't read. The student received one-on-one instruction in reading, writing, and math. He had several accommodations, but they didn't diagnose the dyslexia until the student was in high school. And that's when the this new special ed teacher started voicing concern. She's like, wait a minute, this kid's been passing every grade and he still can't read. There were even emails with the teacher saying this that were introduced during this case. Well, this is when you have to be very careful. And the court made a point of saying you can give so many accommodations that
Hey, how's it going today?
it really
I'm
amounts
good.
to
Got a question for you. I just got a voice.
a modification and not holding the child to regular state standards, which then can be a denial of a free appropriate public education. Whereas the accommodations in the area of math were like use of calculator and some other things, but the child was actually making progress and being able to do math. The same was not true with regard to reading. It was after the special ed teacher said, you really need to look at whether your kid has dyslexia. The parents took the child out, had the child independently evaluated. They determined, yes, he has dyslexia. She took those reports back to the school and they said, oh yeah, he has dyslexia. Then the parents started paying for outside tutoring services. And unlike the previous case where the parent said it's because of what I'm paying for, and the district said, no, it's what we're doing. But there was without a doubt a data to show the child was making progress. Here, data was probably the most important thing because the district its argument couldn't be successful because this child had gone all the way to high school without making any measurable progress with regard to reading ability. But once the parents started paying out of pocket, there was data showing that the child was able to make progress with regard to reading. And the court said it came down to two questions: whether William could learn to read, and whether learning to read required something different than what the school offered. Well, all the way up until 11th grade, he was not learning to read. He was not reading. But once these outside services started and there was data, a lot of graphs, a lot of data showing what the outside provider was doing, he actually did learn how to read. So the answers to both of those questions were yes. So the court then ruled in favor of the parent. The only thing is they did not order that the district, they ordered compensatory services, but they didn't order the district to use the person who the district wanted to use. So again, just advancing from grade to grade does not equate to a fate. They said the fact that this kid was getting passing grades in ELA without being able to read were the result of some of the things that were happening. And here were those particular points. Of course, the district wasn't doing anything different in their instruction. Yeah, he graduated, but they had workarounds. Instead of teaching him to read, when he had something to do, like write a paper, he was using speech to text. Then they told him, and this was written in his IEP, take the speech, what you've gotten out, you've produced using speech to text, put it in AI software like ChatGPT, let it write a paper for you. Then put it through Grammarly, then cut and paste it and turn it in. That they were not measuring the work that the child could do. They were measuring how efficient ChatGPT and Grammarly were, and the outside provider said the thing is, with any instruction the district was providing in reading, they never went back to those basic reading skills. And until they went back to the basic reading skills, the child was not going to learn to read. This case on Pierre Noel, I'd done one of the previous decisions before. This is the child who's medically fragile and in a wheelchair, where the parents weren't always available to bring the child down the stairs from the outside of the building to the curb. This is where we know transportation can be door to door, curb to curb. And that's what was in this child's IEP. The question was, what about when there's stairs between the door and the curb, or the door of the house and the door of the school? In this particular case, the federal court, and this decision ended up being upheld in 2024, was that yes, transportation is broad enough, the term transportation is broad enough that it can mean literally from the door from the door of the house to the door of the bus, from the door of the bus to the door of the school, including down those stairs. Of course, the district had a policy that said that staff would not lift the child or lift a wheelchair to load a child onto the bus, that the parents had to get the child to the bus. But if the child couldn't get from the door of the house to the door of the bus, the court said then the child doesn't have access to their education. And they're saying you don't have to use district staff to do this. You could contract with an outside service, but for that child to actually access transportation and then access the school, the child is entitled to whatever's necessary to get from the door of the house to the door of the bus. But they said you don't have to go on the other side of the house. And then a similar type ruling came out in this decision from June that also looked at, and this one was a New Jersey case, and it said, yes, door to door is from the door of the house to the door of the transportation, the bus or the ambulatory service, however the child's being transported, but that no, you don't have to go inside the house on the other side of the door to get the child dressed to get to the bus. The next couple of cases are actually state cases, but they are recent cases, and they deal more with students with disabilities and alternative school programs. So these are additions. They're both out of Louisiana, and because Louisiana has those parishes. Here, there was an alternative school program. It had kids from 6th through 12th grade. In this particular lawsuit, it was bought by the Southern Poverty Law Center on behalf of this child and some similarly situated children. And it dealt with kids who were being expelled, and then they were sent to the alternative program. And they looked at this particular alternative program, and they looked at the population of kids, and they looked at how many kids were there and how many were kids with disabilities. And they said that although the school district itself was 2/3 right with regard to the makeup, the race of kids, that this particular alternative school program had a majority of African American students. So they said it was disproportionate to the makeup of the particular school district. And they said that also when they went through the expulsion hearings, or when students were assigned to this particular alternative school, that they would coerce parents to voluntarily place their kids at the alternative program, and they were presenting parents with waivers so that they would waive their due process hearing rights and then not actually take them through an expulsion hearing. This is a case with regard to basic due process rights. If this was a non-disabled child, to go to the alternative school, they would have gone through a disciplinary hearing. What, in essence, was being alleged here is that these kids were not being afforded the right to the regular disciplinary process. They were going through the IEP teams or going off books and asking the parents to consent to a change in placement to the alternative schools, not as an expulsion, but as the parents' agreement to a change in placement. But then they would have the parents sign a waiver of their due process rights so that there was no opportunity for an actual hearing to contest whether the student was actually had actually violated the code of conduct. And so they, even though there were supposed to be time limits when parents signed these waivers, it became an out of sight, out of mind kind of situation. And they told the kids they had to earn their way back into their regular school programs instead of having an actual plan with measurable goals and time limits on them getting back. And one of the things that was also alleged and that the court found was that one of the things I'll say, just because you put it in the IEP doesn't make it legal. So what there was a tendency to do was to put in the IEPs that the students needed a smaller setting, but there was no real data to show that the child would be more successful in a small setting or in the alternative school setting than they would be in their regular school if they had appropriate supports, services, interventions, and to reduce, replace, or eliminate the negative behaviors. Once they went to the alternative schools, they said that the policies were punitive. They couldn't participate in extracurricular activities, sports, prom. They couldn't, and students with disabilities couldn't bring backpacks. But yeah, and they said a lot of the kids spent all their day, guess what, on a computer completing Edgenuity courses rather than receiving appropriate supports to address the behaviors that led them to be there. They weren't receiving their social work and counseling services. And then this, I found this one a little shocking. The district also had some type of an arrangement with LSU, where LSU was doing some type of experimental program, and they were through their psychiatry fellowship program, where they were then medicating these kids through LSU Department of Psychiatry. So let's just say there were a lot of problems with regard to disparate impact, with regard to medicating the kids. And they also said, even though that because these kids they didn't have appropriate staff for not only special ed, but also for the gen ed population. So these kids were not getting their regular high school credit, which meant they couldn't compete for scholarships, and that whereas there was an over 80% graduation rate for this particular district, that students very rarely graduated with a state high school diploma who went to this particular alternative school. So they ended up through the court, there was a settlement, which was probably the best thing possible in this particular situation. And one of the main things was if there's a disciplinary referral to the alternative school, there has to be a definitive exit date. There has to be a plan. They have to get all of their due process rights. You must do manifestation determination reviews, because in a lot of cases, those weren't even happening, neither for the kids with IEPs nor the kids who had 504 plans. They said that they had to remove any policies that were and practices that were inconsistent with federal and state law, revise policies, procedures, handbooks. They gave them 30 days to do those things. But they also said before anything could be finalized, they were going to have to run all their proposals through the Southern Poverty Law Center to give input onto the revisions to their policies and procedures. And they also found that this district was not appropriately reporting their OCR data with regard to these removals. All the staff had to be trained on the policies and procedures, restorative justice, trauma-informed approaches, all of that had to be done by July 31st of this past summer. There were also some undisclosed monetary payments to the affected students because of the loss of rights. They awarded attorney fees, and all of this was through the settlement. There was a whole lot. It was a lot with regard to actions as well as monetary repercussions for the school district. This one is also a Louisiana parish case that was brought by the Southern Poverty Law Center against this particular, and the law school, the Stuart Smith Law Clinic at Loyola, as well as the Southern Poverty Law Center. This case, there's a 14-year-old student. He was attending a charter school where historically a lot of kids who had involvement with the Department of Juvenile Justice, you would find them going to this particular charter school. However, when the child went to transfer back into his home school, there was actually nothing in his record that showed he'd actually been committed to the Department of Juvenile Justice. So there were a lot of questions when they saw this on the child's records, and they started questioning the parent. Why was he at this charter school? And the mom was like, basically, mind your business. There's nothing in the records that shows he had a court sentence. Why he was there is none of your business. He went there. It is a public charter school. Just because most of the kids it's a structured environment for kids who've had some issues and some involvement with the law. There's nothing in his record. I'm telling you, there's nothing you're going to find that shows he was ordered there by the court or that he'd ever been at DJJ. Well, because they thought he'd been involved with DJJ, they told this mom he couldn't come to his school. Basically, go home, wait until you hear from us, and then we'll let you know what our decision is. The mom was like, look, he's not been incarcerated. We live within the jurisdiction of the district. I have other kids who go to this school. My kid is entitled to enrollment. They were like, again, we'll let you know, but if you insist on him going to school, he has to go to the alternative school. And within 15 to 45 days, we'll let you know whether he can go to his regular school or not. This is one of those things that kind of lines up with the Department of Justice. When they see a district that has certain policies that says if you come from the Department of Juvenile Justice or an RTF or a group home that you must go to an alternative school, at the federal level, they will usually find that that is a discriminatory act. And so that gave the Southern Poverty Law Center and this law school some legs with bringing this claim. Mom was like, look, you don't let my kid in, I'm getting a lawyer and we're going to fight this. My kid hasn't been expelled. He's not on a long-term suspension. You have nothing to show that he's been in DJJ. How are you going to just say my kid has to go to the alternative school and he hasn't done anything to violate the code of conduct or anything that would match up with your policies and procedures to say he has to go to the alternative school? Well, the long and short of it is the ruling was in the parents' favor and the district's having to change its policies, procedures. And they said that this was a violation of a property right and due process rights for this child. And it went back to the Supreme Court case of Goss versus Lopez, where it said that children have a property interest in their education, and to take it away without them having the opportunity for a hearing and giving them their rights, that it violates the due process clause as far as federal law, because you cannot deprive someone of life, liberty, or property except through due process of law. So when you send that kid to the alternative school without due process of law, you have violated federal law. So again, the summary is the rulings in the parents' favor. There was an agreement, settlement agreement, where there are a lot of things that have to be done with regard to execution of the settlement agreement. Some state-specific things. Remember the non-certified teacher pilot program? Does special ed teachers are not a part of that. There is also some non-regulatory guidance with regard to students in foster care. And I've got the links here in the presentation. OCR, it's been up and down and all around since January with OCR. The OCR, even when that lawsuit was filed back in the spring after the March executive order that was basically getting rid of the U.S. Department of Ed, in May, the federal court, ordered that the Trump administration reinstate laid off employees from the U.S. Department of Ed. And then when the U.S. Supreme Court said, oh, the president does have the right to basically dismantle or to get rid of federal employees without there being cause, that was in June. There was actually a particular piece in that court order that kind of said, except for the Office for Civil Rights. And there was a part of that where the federal government was ordered to bring back employees from the Office for Civil Rights and to have a plan for them to come back. So OCR was actually coming back up until the shutdown, and they'd also started back with regard to processing complaints. And one of the things is they did what I call, with a lot of the cases, they went after low hanging fruit because they needed to show that they were back in the business of investigating complaints. Most of the resolutions that you'll find over the last few months, a lot of them dealt with FAPE with regard to IDEA and 504, evaluation timelines, disciplinary procedures, inequitable facilities, whether the counters are the right height, whether the football stadiums are accessible for people with disabilities, whether the parking lots are accessible, also service animal cases. With regard to discipline, most of the cases that I found, a lot of them dealt with manifestation determination reviews and whether those MDRs were held and whether they were held within the appropriate timelines. And this Wyndham Academy complaint, this one, and this is from the 24-25 school year, you'll find that even though there are a lot of much older cases, that they went with some of the more recent cases and looking at for the case resolutions. This kid had some physical altercations and other incidences. He had out of school suspensions. This one really dealt with when the child got past the 10 days and doing the MDR. Okay, so we got into January of 2025, and it was for damaging the computer and that particular incident that was going to put the child over the 10 days. Well, the parent was put on notice, but then in the interim, they ended up referring the child for expulsion. So he didn't come back to school when he was supposed to because they ended up doing the expulsion for the kid. After the expulsion hearing, the chairperson of the board of trustees told the parent, the vote is that he's going to be expelled, but it's going to be about 4 days until we get the official notice out to you. So OCR, again, consistent with what we've been saying, even though those days were connected to, they were like, oh, he was out waiting for the official notice to be typed up on the expulsion. They said, no, those were days of suspension related to the behavior. So those days count. So there should have been a manifestation determination review. And they found that they were in violation with regard to not conducting the manifestation determination review in a timely manner. But there was an additional twist here. One of the things was that the kid ended up transferring out. And I think I went a little far, a little fast. They ended up transferring out. And they said, well, he transferred out, so we can just let this go. We don't have to do anything because the kid's gone now. And OCR said, wrong answer. Even though the kid transferred out, before he transferred out, you should have had the MDR So you're in violation with regard to not having had the manifestation determination review. So even though the kid is gone, we are still going to find you in violation. With health services, there were a couple of these complaints that dealt with nursing services. And it just reiterates the fact that when the kid can't come to school because you don't have appropriate training in place for your school nurse, or you don't have a school nurse in place, that those days will count as exclusions, and OCR will look at it possibly from a denial of faith perspective as well. You know, this particular child, and in this first case, the child was suffering from long COVID, and there were some different things there. So the child was out of school. They said that the district did not put in place appropriate services, amount type of services with regard to the kid, even though there was evidence that because of the health problems, the kid was falling behind, that they had an across the board policy that you had to come to school for a certain number of days to get your seat time, even for medical homebound, that they had a minimum, you had to be in school for 2 classes at a minimum. OCR, they said that no, that kind of a policy is discriminatory because you're not looking at the child's individual needs, you're looking at your across the board policies. And so they should have looked at what the kid needed with regard to accommodations and not just what their across the board policy was. Here, the kid had diabetes, they had an IEP, they put in the in the 504 plan that what the school nurse's responsibilities would be with regard to monitoring the child's sugar levels and administering insulin. But when the kid showed up after they had the meeting, the kid had a different monitoring device. The kid had the pump, the cell where it was monitoring and then automatically releasing the insulin that the child needed. The nurse said, "Oh, I don't know how to use that. We talked about me measuring the child's blood sugar and then me giving the insulin. I don't know nothing about this pump." And she said, "We don't have a policy and procedure in place for this pump. So kid, you need to go home until I figure out what to do with this pump." Then she had contacted the West Virginia Department, State Department, the Department of Ed, as well as the state school nurse consultant. They said, "We've got to get a policy and procedure, then we've got to get people trained, and then you can come back to school." And they said, "But mom, you know, you can come and train us, and that'll get the child back into school earlier." Well, that didn't happen. So the kid ended up being out of school longer. This was for the premise of it's the, you know, because you have that wrinkle of where school nurses say, well, if I don't have specific training or procedures, I can't violate my licensing requirements. But on the other hand, we know under 504 and the ADA, the child has to be in school, and it's the school district's responsibility to make sure that the health services are in place. And then there was also the problem of what instruction did the student receive while the student was at home, because the school district didn't have appropriate procedures in place for the insulin pump. This next case also deals with the fact that they had problems with getting school nurses, and they would call the mom to pick the child up if the school nurse wasn't there, or either the mom had to come to school with the child. That was pretty clear. You can't do that because because the nurse isn't there. You can't either say kid has to stay home, or mom, you got to come to school with the child. That's pretty clear. There were 3 service animal kind of cases that the OCR looked at. This one is real easy. The dad comes to the parent teacher conference. In this case, it's the dad and comes with the service animal. The administrator is very abusive to both dad and the dog, even called the dog stupid. And yeah, not good. This next one is 2 service animals. Student A and student B both show up at school with service animals. The district's like, oh my God, okay, this will work. But then service animal B attacks service animal A and the student during the day. In fact, the student A ends up with injuries from alleged service animal B. Service animal B is barking, not totally under the control of the child, not really meeting the requirements of a service animal. With regard to students being, the student A then was frightened of the service animal, alleged service animal B, and feared for her safety. So they said, okay, we can't discriminate, so what do we do? So student A, they said, what we'll do is adjust her transition time. We will let student A leave class 5 minutes before the end of lunch each day so that she misses alleged service animal B. They don't come into contact with each other. And looking at this case, I said, oh, what a great spoiler alert. Obviously, OCR didn't really think that alleged service animal B met the requirements of service animal because they actually said they had concerns that even the 5 minutes of missed instruction for each school day, they said, we're going to add that up per day, per week. And we believe that student A is being discriminated against because she's being discriminated against because of the bad behavior of alleged service animal B. Okay. There was
Barbara,
another, I know,
excuse
yeah,
me.
we're at the end.
Okay, I thought when I saw that other slide, go right ahead. I'll be quiet.
Okay. Yeah, let's see. I think I ended up doing the end instead of the next slide. This one was probably the last OCR decision before the break in service for 40 some odd days. And this one, prior to moving to Missouri, the parent had requested an evaluation based on a diagnosis from a medical doctor. In 23-24, the new district met. They said, we're going to do an evaluation for 504. We're going to set up a meeting, and here we need you to sign the consent form. The parent never confirmed attendance at the meeting, didn't return the consent form. OCR said, you're good for 23-24. But when 24-25 started, the parent provided more documentation from a physician of new diagnoses and said the child is being treated for these particular conditions. Then the student came to school and went to the principal and asked if he could bring his dog to school. Your dog? Okay, tell me a little bit more about this dog. And remember, under the DOJ guidance, there's really only 2 questions you can ask. And this principal followed the rules. He asked, what disability and what task or work will the dog be performing? The mom, according to the principal, the mom never really answered those questions. So they said, this is not a service animal. This is a comfort animal. And we don't have to allow comfort animals in school. Of course, when dealing with OCR, the mom said, oh, we've had this dog since 2022. He wasn't originally a service animal, but we trained him. And these are the things he's trained to do. These are his tasks or work that he's supposed to do. So based on the conversations between OCR and the school district, they ended up letting the service animal come in for the 25-26 school year, which resolved that particular issue. So you think this is over, right? Nope, but wait, there's more. Do you remember the original evaluation request during the 23-24 school year? They said, you're fine on that one because mom never gave you written consent to complete the evaluation and didn't participate. However, at the beginning of the 24-25 school year, mom gave you more information, more data from the doctor, and they made the request for the service animal, which should have triggered child fine. And that's where they then said, that's where you now have a problem because you didn't attempt to go back to the table in 24-25. Once the mom brought you additional medical information and you knew that there was a service animal involved because the child allegedly was having panic attacks and suffering from anxiety, they ended up signing an agreement back in September, but they only gave them like a month. And they want for them to get the kid evaluated, to determine eligibility. And on the issue of compensatory services, usually we're seeing compensatory services strictly with IDEA. They also said if this kid is eligible, you've got to look at compensatory services and IDEA for this particular kid based on the mental health issue. We talked about some of the transportation stuff already, and I think I'm out of time at this. So I think I'll go ahead and end here.
Thank you so much, Barbara. Yes, you are. But you know, we could just have like an all-day session with you. We did have one comment over in the chat box, one individual thinks he might need accommodations to keep up with your presentation. Definitely, he wants to request extended time. And I see hearts and claps going up from the reaction. So we always love having you come and talk to us because we learn so much and you keep it entertaining. And we do have one. Oh, wait, we're just dying to know, like we're on the edge of our seat. What was the outcome of the West Virginia nurse issue?
Well, they said, we understand the licensure issue versus you've got to have accommodations in place. But because this is education, you needed to have moved quicker to get whatever training the nurse needed with regard to this pump. And it was, and I'm not saying it wasn't, especially since you're only talking about it was like in the last year and a half, where the nurse said, an automated pump, I don't know what to do with that. How does this thing work? How do I know that it's giving the kid the appropriate amount of insulin? How do I know it's correct? I don't know nothing about no pump. And they also said this is the first kid we know of with a pump.
Wow. Yeah, they'll be seeing more of that for sure. Joyce, you had your hand up earlier, but then I see you just put a comment. Just awesome, Barbara, as usual. Joyce, did you have a question also? Joyce Cunningham? I'll give you a minute to figure out how to unmute while I go on to the next comment. Tabitha wrote, thank you, Barbara. Oh, and Joyce says no, she doesn't have a question. Can we get a copy of your presentation?
Yes.
Okay. Yes, and they would love to share it with administrators. And oops, somebody else's hand just went up, but then it went down. Adam, I think it was. Did you have, or did you just mean to clap? Okay. When you were talking about the St. Bernard Parish case, did you say the ratio in an alternative program should be representative of the population of the district?
That is one of the things that the court looked at. They looked at, because they brought IDEA, 504 and ADA claims. So part of their claim was that kids of color were being disproportionately assigned to the alternative school.
Gotcha. Does that answer your question, Elizabeth? Okay. Well, Barbara, we'll keep an eye on the chat, and if something else comes up, and Elizabeth says, yes, it does answer her question. Thank you. So thank you again, Barbara, for coming and speaking with us. And Peter, you are next. I know it's a tough act to follow. Thanks, Barbara.
That's right. Barbara insisted on going first. So I told her, tough act to follow. So I was, watching the U.S. Department of Education website. So that was the only press release so far they've issued today is their agreement, 6 interagency agreements that Barbara described. You can go to them. I'd recommend, I follow them on X, the artist formerly known as Twitter, and you can kind of get updates from them. As far as the Office of Special Education Programs, as part of the reopening of the government, the deal that was made, they did basically reinstate, at least temporarily, the employees who had been part of the reduction in force, the RIF notices that went out to the Education Department employees. They were reinstated, and the RIFs were, at least for the time being, removed. and they did return to work. We did receive just some emails from our representative here from OSIP for South Carolina. Her name's Rhonda Sortino. She did reach out to say that she was back to work and digging through about 45 days of emails. So that's what she's doing so far. But we haven't had a chance to meet with her, but they are back to work. The deal it appears to say that they would be back to work at least till January. So we'll see what happens then. Since that time, if you follow the feed on X from the U.S. Department of Education, there's been a series of tweets or whatever that talk about the shutting down of the U.S. Department of Education. So, one of them is Secretary McMahon talking about how there was 45 days without an operational office, and yet, school still went on. There's another one that has some clips from some presidents throughout time, a couple clips from President Reagan, a couple clip from the first President Bush, and then updating to today, talking about the need to shut down. So it appears that the administration is still seeking, obviously, making it clear that they would like to shut down the U.S. Department of Education. So we're not sure. I mean, it's still a lot of uncertainty at the federal level as to where the IDA will ultimately rest. But for now, we do have OSIP. They do still exist. They do have their employees back who were there prior to the government shutdown, and so they're back to work. So we expect to hear from them soon on that as well. So that's kind of our current status. I mean, like Barbara said, regardless of that, the laws and the regulations are still in place. So and our state obligations still remain in place, and there's really no talk of any change to that, right? So I'm going to focus today mostly on what we're doing at the state level and some pieces that we're getting from OSIP, just from a few things that we have, because I know basically we give updates about once a year. I update you in our LEA sessions pretty regularly on things as they occur, but once a year I like to just recap kind of where we stand on things. So we're going to talk about some OSIS information, a couple of reminders of things that might be going out that just in case you didn't hear about it or are some of our new directors, to talk a little bit about that as well, and go over again our priorities and our critical areas of need as well, those that we've set for the office. And the priorities really haven't changed. We've been just talking about this for a couple of years, but I just wanted to, in case there's some new directors out there, and then go over the data that we have right now as far as our performance over the last few years, just to see what kind of trends we're seeing, and then some recent releases that we had, and what we're working on to further support you in your work. So we're going to talk about that. So some OSIS reminders and so forth. So we sent out the org charts, and this is just if you're interested. So I like to make you guys aware of kind of how the agency's structured, and then our structure here in the Office of Special Education Services. And so you can look at the overall SEDE chart by clicking on that link. And also just recently, Sarah had sent out our org chart for that as well. So it just lets you know, a little bit of who's doing what and who to reach out to and contact. And so we still have the 5 teams here in the office, and I know you guys have become familiar with it, but just to give you an overview of, which office supports what and who you might reach out to. We have the review and analysis team. They do work on addressing findings of noncompliance. So if you receive a finding of noncompliance and you have issues about your corrections, then you would want to reach out to Elizabeth Moore and her team to get clarification on that. And so that's the place you go. If you're talking about improvement support, and those are kind of the programs and then technical assistance that we provide to you guys, you would reach out to Jennifer Dillon, and that would include, the technical assistance for SC teams. You can certainly reach out to them directly, but if you have some questions, you can reach out, and that team helps support that. And then if you have questions about any policy or guidance that we've issued, or any community engagement efforts that we're making at the state level, that would be our policy guidance and community engagement team. So that would be any of the guidance documents that we put out. You can contact Lisa McClimate as well. Data collection and verification, you guys all know, you have regular meetings with Carolyn. So if it comes to the data that we're collecting and any data reports that you're providing, that would be her team. If it's any fiscal matters or related to your grant as a sub-grantee under the IDA, you would contact Michelle Williams-Young. So those are still, like I said, the teams. So that we have it set up to. We have a few new members. Fortunately, we haven't had huge turnover. A few years back, we had a good amount of turnover, but we've been fairly steady in our office as far as those. We've had 3 new additions since the last year that I talked to you at fall admin in 2024. We've added Ginger Daniels. She started as our SCPP program coordinator. She's now going to move to our SPP APR indicator specialist. So if you have some findings related to the indicators, she would be the one to contact to help you with that. Linda Wajtala is our correction specialist, and so she'll be working on letters of resolution coming about our state complaints and corrections related to program reviews. And we just recently added Denise Taste White. She's going to be our SCPP fiscal coordinator. And we're looking to hire a few more in the coming months for a few positions that we have open as well. A couple of things I wanted to remind you of. There is for Reviso 1.3, and this had to do with looking at to see if there's any under or over identification of students in South Carolina for students with disabilities. And so basically the proviso itself just said that, kind of put it to the Department of Education to review our child count data each year and to look to make sure that the percentages are within a reasonable range based on national and state data. And I'll be looking at that data in a second just to kind of show you where we are. But basically what it ends up doing is the way it cut, the nation is a little over 15%, and we're right around 15% in the state of South Carolina. So it mathematically ended up pretty easy. So what we tend to do is we see if we see a district that has less than 10% of students identified as students with IEPs or more than 20%, then we'll take a look at what's going on and see if we can provide any technical assistance, because that's a little bit outside of the range. If you looked at this in a bell curve, you're going to obviously see that most districts are going to fall the vast majority between 10 and 20% of their student population will have IEPs, and that's been pretty constant for a while. So we just have a few that fall as outliers outside of that range. And it doesn't mean then that there's anything necessarily wrong, but it's just to look at the data to see, where the students are being identified, and possibly look into different evaluation criteria and things of that nature to see if any adjustments need to be made or if it's just a statistical outlier. But that's just that. In case you receive a letter, that's what it's about. It was a request from the governor's office that initiated this, and they're basically saying, let's just make sure we're not under or over identifying our students with disabilities. The other one is just another reminder. I've reminded you guys of this a few times, but this is next school year. We just have to be cognizant of the fact that there is a new law and a regulation that went into place pursuant to that law on educational interpreters. And so it's setting a minimum set of standards for educational interpreters. So for those interpreters for students who who are deaf. And this is, it establishes a minimum of competency at 3.5 on the EIPA, and a minimum of a high school diploma for those individuals. And you have to have completed the EIPA written test. The other ones are just a sworn statement, signing a sworn statement, and that you'll adhere to the standards for interpreters, and then a background check. It also will begin that your education interpreters who you employ will need to start accruing continuing education hours, just like other educational professionals. You have to accrue it. So the requirement is 80 hours every 4 years. So it's at the pace of about 20 hours of continuing education per year. So that starts in 26-27, meaning that they would have to complete the 80 hours 4 years from the beginning of that school year. So for the 2030 school year, they'd have to demonstrate 80 hours of continuing education in that 4-year period. So, all right. So let's talk about the priorities, and we've, like I said, this slide should be familiar at this point. We really haven't changed it, and this is just what are the functions of our office, and these are set by statute and for the most part as to what we're required to do, especially the first part, which is to develop and maintain an effective and comprehensive system of general supervision. So there are many regulations that are contained in the IDEA that pertain to state functions and state responsibilities. And they refer to, kind of collectively, we refer to them as general supervision. We've set forth those in our general supervision guide. It is available. If you look under integrated monitoring on our website, you will see that there's a tab for a general supervision guide. I've referred to it before. I think it's on your Google Drive. If not, we'll put it up there again. But it's been available for some time. We drafted this almost a year and a half ago now. We released it in the summer of 2024. So that describes how we conduct our general supervision here in South Carolina. It was done in part due to the review that we received from OSEP, from the U.S. Department of Education. They did as part of their differentiated monitoring system, or DMS. We were reviewed in cohort 1. And they did have some findings with respect to how we conducted general supervision. And so we looked at those. We also looked at a guidance document that was issued in 2023 that set forth all the requirements for state agencies. And we reassembled and kind of updated our general supervision guide and provided that as evidence to them. And I'll talk a little bit more about that in a second. So we have that, and so if you have any questions about that, consult with the General Supervision Guide, and you can certainly reach out to us. But this includes all kinds of things, including our program reviews, our indicators, and how we review those, significant disproportionality, all those requirements that we're required to do as part of the IDEA and the regulations, and the systems that we use to do that. It also describes our determination system and how that works, and our tiered levels of support based upon those determinations. So that's it. I mean, these are all the have-tos that IDEA requires of a state agency, and that OSEP has directed us to have and to do, and so we have those set forth there. The other priority that we have in our office is to provide timely and meaningful technical assistance and support, and that's from those who work here at OSIS. Obviously, you can reach out to us. We regularly provide technical assistance and support. Barbara, also from the Office of General Counsel, provides when districts call with questions or and need answers, and then any of the staff here at OSIS. But in addition to that, we've set up the Technical Assistance Network, SC Teams, and to support you in your work, and to encourage the best practices we can throughout the state for educating our students with disabilities. And so that's that's a big part of our work as well. The other one is, when we can, to develop programs and initiatives to address the critical areas of need for the state. And so those are issues that are state level issues that really districts need assistance with, that we need to focus on at the state level and can effectuate some change at that level. Sometimes it's not something that's within our purview to do, but when we can, to develop some programs to do that. So we see that as kind of our mission as to what we need to do. We need to have that general supervision system as required by law and regulation. We need to provide timely and meaningful technical assistance and support to help you guys do your jobs, and to help our students with disabilities, and to develop programs and initiatives when we're struggling on a state level, or when there's an area of need that we really need to address. And so I don't think these will come as any big surprise. We've talked a little bit about this before, which is what are our critical areas? Well, I mean, based upon the data that we regularly look at and submit to the federal government, we need to improve our ELA and math instruction and improve the outcomes for students. And I'll get into the data that we have in a second. We also need to look at our graduation and dropout rates. For both ELA and math, and for graduation and dropout, we were in the bottom third of states. And place that, and that's on our statewide determination. Those are part of the things that brought us down, and that's another area that I'll cover in a second as far as that data goes. The other thing we're seeing, and we're hearing this from you guys a lot, obviously this is certainly post-COVID especially, we're hearing a lot about student mental health issues and behavioral issues that are occurring, that are disrupting the educational environment, and how to address those, and that it's become more and more challenging for districts. And the other one is an issue that built up for a number of years, possibly decades actually, as the teacher service provider shortage. We've had a shortage for years and years and years in the area of special education. That shortage intensified as it did for all educators. There's just not as many coming through the traditional pipelines that we saw in years past and decades past. And so that's led to a pretty big shortage, not just here, but nationwide, for educators, and particularly for special educators. So let's take a look at the data. And first, I'm going to actually just start at our determination as a state, and start with the DMS status, because I spoke a little bit about this. And so this is OSEP. So this is the Office of Special Education Programs at the federal level. And we were part of, like I said, we were part of DMS cohort number 1, meaning we were the first group under the new system, 2.0, I think they called it, was their new one. They're on cohorts 4 and 5 now, although that did get disrupted due to the shutdown, as I understand it. So we'll see if that gets taken back up, and whether the ones in the later cohorts, the states that fell in the later cohorts, whether their monitoring gets completed or gets delayed. But ours, and they was issued on April 23rd, 2024. As part of the corrective actions, we were to submit policies and procedures updates. We did that within 3 months, which was the required timeline. So we submitted it on July 22nd, 2024. And that's what you see on the general supervision guide. There was a couple other policies and procedures changes that were on our website, and in some documents that were posted on our website, we made those changes. But the most significant document that summarized all the different things that we were doing in order to meet the requirements as laid out in that report that OSEP issued were set forth in that general supervision guide. And so that's what we did. And then so after that, they say, okay, well, first, make your revisions to your policies and procedures, and then implement it. And then show us evidence of implementation. We did submit that. So it just like you guys, when you have findings of non-compliance, the statutory rule is as soon as possible, but no later than a year. So we did submit our evidence of implementation on April 21st, 2025. So that was earlier this year. And basically, we've been, in contact with OSEP. It appears that we've met everything that they've asked for. We're just waiting on the clearance letter from them. So the final letter acknowledging that we did in fact adopt appropriate policies and procedures, and we have shown that we're implementing that as well. So that's where that stands. Hopefully next time I talk to you guys, I'll be able to say we received the clearance letter. That's what we're hoping for. So the next one is to talk about our determinations. They're issued in the summer, just like the LEA determinations that we issue to you guys. And they follow the same categories, which are meets requirements, needs assistance, needs intervention, and needs substantial intervention. Pretty much, I don't know, the 8 or 9 years prior to this, our 2025 state determination was needs assistance. We had gotten 63% of the points possible. Our results points were 8 out of 20, so results would be similar to the performance indicators. And then our compliance was 19 out of 22. So where do we lose the points? Our indicator 13, we had a decrease in the percentage of files essentially that we reviewed for indicator 13 that met the indicator 13 standards. And so since it was a decrease in the amounts and in that percentage, and this is they're looking for 100%. Compliance on that one, so we lost some points on that, and then the general supervision, the ones that we needed to, there was just some data points that they said were missing, so we had 1 point off on that. But the most of the issues came on results. Our participation numbers, so they look at both participation and performance on NAEP, the National Assessment of Educational Performance, which is also called the nation's report card. As you guys know, it's given once every 2 years for math and ELA. And so this was based on 2024 NAEP scores. There was no administration of math and ELA 4th and 8th grade in 2025, so it'll be administered again in the spring of 2026. But participation, we got full points for, but for the performance, we fell in the bottom third for math and ELA for both 4th and 8th grade. So that was 8 points possible on that. So we got 0 points out of 8 on that. Our graduation rate also fell in the bottom third of states, and so therefore we got 0 out of 2 points, and our dropout rate was in the bottom third as well. So those were ones how we did it. So that is basically our determination. If you want to see the matrix, we can post that as well. It's just a breakdown of the points, but that's the summary of it. As far as our, as you guys know, we just reached our child count date for this year, but for last year's, so we're looking at last year's now. This is, we haven't tallied up this year's child count. There's still a few. We'll probably get that by the end of the calendar year. This year we'll know our child count, but for right now we're looking at 2024. We had 114,284 students with IEPs in the state. There was a slight decrease in the overall population, so it led us to, we were up to around 15% of our overall student population. So we were in the 14s. We were gradually moving up over the years. As you can see, there's been an increase in the percentages. But where does that sit nationally? Well, the last time they updated that, NCES at the government updated their data, it was for the 2022-2023 year. So it's a little bit behind. I mean, that was what we were just looking at. The 114 was for our 2024 child count. So this would have been a 2022 child count. But at that point, the U.S. average was 15%. It's gone up a little bit since then. So it's probably maybe 15.4, 15.5 at the U.S. And at that point in the 2022-2023 year, as we saw, we were at 14.2%. So we're just under the U.S. average, and that's pretty much where we sit, because we've gone up, but so has the U.S. average. The state range at that time was 12 to 21%. So we saw that some states were identifying a little bit less, and some states a little bit more. But the bottom line to all this is we're like just below the national average as far as our identification of students with disabilities. So now let's look at our ELA performance, and we're just looking at the last 4 administrations of NAEP, going back to 2017. So we see like kind of pre-COVID and post-COVID, but the standard has been pretty much the same. We did get closer to the national average. So this is apples to apples. This would be South Carolina's percent at basic and above on the NAEP compared to the nationally for students with IEPs. And the same for 8th grade. And as you can see, we many times, we're starting in 2017 over, 11% below the national. And then that gap was cut a little bit. The national average actually went down in 2019 and 2022, and South Carolina's went up slightly, cutting it to 5% in 2022, but then back up to 7% difference in 2024. So we're still lagging behind the national average, and the same thing on 8th grade. There's been a very large gap in 2017. We did see a decline nationally for the performance of students with disabilities, and it got cut to 10%, but then it went back up, and we're sitting at about a 12% difference, 12% below the national average as well. So, and then if you look at mathematics, pretty similar. For 4th grade, the national for students with disabilities has stayed about the same. It was 45% in 2017. It's still 45%. Our percentage has gone up, but we cutting the deficit, but we're still well below the national average on the percentage of students who score basic and above on NAEP. The 8th grade, unfortunately, we've seen a decrease in our 8th grade students with IEPs who receive a score of basic or above. It's gone down to 10%. The national average has gone down as well for 27 to 23, but once again, well below the nation on that. So let's turn then to, so we're looking at that, and we know, this to a certain extent explains why we have so many schools that are ATSI for the subgroup of students with disabilities. It obviously shows why we're in needs assistance for IDA implementation and the determination, the state's determination. But we are seeing a trend in a more frequent assessment. Obviously, we do this every year. We do SE Ready, and so. We're looking at that. There is a positive trend up for ELA performance. So there's a lot to think that we're going to see some hopefully some increase on the national assessment on the NAEP. And so this isn't taken from indicator 3. There's a slight difference for that, and we explained that at fall admin. But basically this is just from the overall data set that's released, and it's just slightly different as to the students that you count for indicator 3 is determined by the federal government, and it's slightly different than the snapshot that we take when we release report cards here in South Carolina and release that data. But basically they end up being within a percentage point or two. But we do see the trend going up both in 4th grade, and if you kind of look back, we had COVID, and then we had the first administration post-COVID 2021, and things kind of got back to, the status that they were before in about 2022. So we kind of use that as a baseline year of where we're headed, and there is an upward trend since then, both at 4th and 8th grade. We had 18.2% scoring meets or exceeds, and we're up to 23.6% in the most recent administration. And then the 7.9 for 8th grade went up to 14.6. So we saw, significant increases. This is one of the bigger trends, better trends we've seen in a number of years as far as ELA performance. So it's a good sign. And with all the emphasis that's been put on the science of reading and letters, which should be translating to better core instruction, is translating to higher scores. And then we also see, so another way to look at it is what about approaching as well. Are we seeing some better results? And we are. The approaching is in orange here. So if you look at 2022, we only had 17.7% of our students with IEPs were scoring at approaching, and that's increased, almost 9%. To 26.2. So we're moving that from, and you usually see, of course, when that increases, and you also see an increase in meets or exceeds, that you're going to see a decrease in those who are in the category of do not meet, and that's gone down from 2022 at 64.2% to 50.2. So we're seeing a 14% decline in that, which is great news. So we want to see, the yellow bar go down and the orange bar go up. And then, ultimately, they get to the other chart that I showed, which is the meets or exceeds category. So we do see a positive trend in many ways for our students with respect to ELA performance. 8th grade, we're seeing some of it, not as much movement to approaching, but from 2022 to 2025, we did see a 3% increase in approaching, but we also saw almost a 10% decrease in does not meet. So we are seeing a positive trend there, not as significant as 4th grade, but certainly important. So these are really good trends to build upon. In math, there hasn't been as much movement, but there's been some upward movement in meets or exceeds. We saw from 2022 about a 3% increase. We saw a greater increase in 2024 and a slight decrease this last year, both at 4th grade and 8th grade. So this reflects that. But it is definitely an area to work on, especially when you see, such low percentages in the 8th grade to work on. So that would be the next emphasis. So this is slightly different. This is looking at if you pull together meets, exceeds, and approaching, and I put 4th grade in green and 8th grade in blue, and then so we want to see this increase over time, right? So we have seen some uptick in math with respect to the number of students who meet, exceed, or approach. And so from 2022 to 2025, we see a 3% increase in 4th grade and a 4% increase in 8th grade. So we are seeing that trend up a little bit, meaning that students are getting closer to that meet or exceeds level. We're getting a higher percentage of students doing that. And looking at graduation and dropout rates, we're calculating 24, 25 now. So when I get that, we'll add this to the chart. But we have seen a positive trend in past years, starting from the 2021, 2022 year, where our graduation rate was only at 53%, and we saw a 6% increase over 2 years, which is pretty significant. And that's, we know that's the hard work that you guys put in. That's really positive. We also look at the combined rate of, are we seeing more students either get a diploma or an employability credential? And that rate has also gone up over 6%, getting up to 67.7%. We're hoping that we can reach 75%, and the goal was by 2030, but we're hoping maybe we can beat that and get to 75% of the students with IEPs getting a diploma or employability credential at that rate before 2030. And then we saw a significant, the last year, between 2022 and 2023 and 2023 and 2024, we saw a significant decrease in dropouts, which is great, over 10%. So we're hoping that trend continues, that we at least maintain at that level, or maybe even get our dropout rate below 20%. So these are also really good news along the lines of ELA. State suspension data, and I think this probably doesn't come to as a surprise to most of you guys, and you've been working with your districts on it, and just asking for anybody to listen to you as far as the suspension data, and we do suspend a large number of students with disabilities in the state of South Carolina, and there was some decrease a little bit pre-COVID, but then after that, it is trended back up. we should have updated data on this soon as well that I'll give to you guys. But as of last year, the 23-24, we were up to 17.6% of our students with IEPs were suspended in that school year and received out of school suspensions. And then in school suspensions was at 14.6%. So both really high rates. And then there was an article that came out, and I just wanted to point out this. There's a couple things about this article that came out about the suspensions of students with disabilities, and it came out in a publication called The 74. But it was based on 2022, 2023 numbers. So that's one thing. The other thing is that so when it's reported to the federal government, you know, obviously all of us know the 10-day rule. That's how we submit our data. Is we send a list of suspensions for 10 days or less, and then suspensions of 10 days or more. And so 15% of the students with disabilities were suspended for 10 days or less. We did have another 2.2% that were suspended more than 10 days. And so that's why it tallies when you see on the performer chart, we counted all of it. Students, it 1 day or more. So any student who was suspended counted, whether they were suspended for 10 days or less or 10 days or more. But the 74 chose to just focus on the 10 days or less. And so they came up with a 15, but South Carolina did have the highest percentage of suspensions in the country. And so so that's something that we need to look at and work on as a state, obviously. The other piece of data to look at is staffing vacancies. You know, we saw it really escalate, and this is focusing in on special ed, and this is according to SARA data, and they usually release in December, so I'll be able to update this also probably by January as far as what numbers we're seeing for 25-26. But you know, the vacancies hit its high point at 23-24. I'm sure you guys all felt that. And while we're certainly not at a good mark now. I mean, these are still too many vacancies for teachers and school psychs and SLPs. So there's still a lot of work to be done. But at least it leveled off and started to come down, and we didn't keep escalating up from those 23-24 numbers where there was real. Start to be some real issues about it, but they still remain very high as well. But we're hoping to bring that number down as well as we move forward. You know, part of the things we see is that we really started to when we started to see this crisis and we started to see those numbers escalated. Obviously, we invested in the program that we had in place, SC Create, and the number of participants. As you can see, we've upped the numbers. This is in its 25-26 is its 23rd year of operation, but it's at significantly higher numbers than it has been for most of its existence. This program is up. We're up to last year we had 662 participants and 148 completers. For that year. We're getting final completer numbers because some people come in a little bit later and finish in August and so forth. But so that's an estimate right now. But the number of participants at 662 is a firm number that had enrolled in courses. So you can see we're almost going from 2020, we're almost double in the number of participants that we have in the program. So that's when the investment has been, but I'll get in a second to about some other initiatives that we're going to attempt to put in place to help as well. All right. So this is just taking a look at kind of where, and this is just a theory of action to say where are we and where are we going is particularly with respect to instruction and to improve academic outcomes. Most significantly in the measures that we use of ELA and math. And so these are kind of the components that we think that will lead to improved academic outcomes. And a lot of this stuff has been put into place, and it's been put into place recently. So the first thing is to make sure we empower our teachers with strong foundational knowledge so that they're providing that quality core instruction, particularly obviously in the general education setting. And so that was with letters training and with the focus on the science of reading and also in math, the foundations of math. to make sure that. The other one is as an agency to adopt and to distribute high quality instructional materials for both core content and supplemental that can be used in that core content instruction. And so in the last 2 years, there's been a significant efforts being made to adopt that high quality instructional material and make it available to districts. And so we were part of those conversations. We do believe that the instructional materials that are out there now are as good as the materials as we've had to support students with disabilities and to support just diverse learners in general, that it's a higher set of content for students and to make sure that we hit the mark when it comes to a variety of students with different learning needs. The other thing is to have clear skill-based standards and then to assess on those standards. And obviously that's been put into place. We had the ELA standards come first. It was assessed just this last spring. The math standards were put into place last year and will be tested this year. So that's going to be a check mark as well. So we've done the first three pieces of it, which is, establishing that core, giving the teachers the foundational knowledge they need, providing the high quality instructional material, and adopting and assessing on clear skill-based standards. At this point, what we think is necessary is that focus on the specially designed instruction and related services and making sure that they supplement the core instruction and facilitate high rates of improvement. And by that meaning, really taking a look at the instruction we're providing in our special education classrooms and just, those that are called for in the IEPs, the specially designed instruction. Is it supplementing what the child is learning in core instruction? And part of that is making sure that the student is receiving their core instruction in the general education classroom and then getting supplemental work as part of their specially designed instruction, and making sure it's consistent and not interfering with it. And we have seen on occasion when we've gone out to school districts that when you review the IEPs and you look at how they're being implemented, sometimes they're very parallel to what's going on in the general ed classroom and really aren't consistent with it and aren't complementing that core instruction. They're causing extra work for the student and oftentimes competing with what the student's able to learn and absorb and doing it. And it should be that repetition of instruction, that additional practice that the student needs to master the skills that they're learning in the general ed, and just making sure we're doing that. And I think that's going to be a key going forward. And I know some of that gets interfered with logistics, with scheduling and making, sometimes it's hard, and we're pulling the students from a student who might have a need in ELA, and they're being pulled from their general ed ELA instruction to receive resource. And that might be just because that's the only time on the schedule that it permits. And those are things that we need to look at structurally to make sure it works. But this is kind of what we're looking to improve in the next year and in the years to come, is really to focus on that and make sure that our specially designed instruction is aligned with that core instruction. So to that effect, we've been very involved in emphasizing the science of reading and the letters training, and we've had our special educators. We made sure that they were included in all that training. Even went to the middle school levels for special educators. And we've also supported, this office continues to be part of the rollouts that we had for the ELA and math standards, and the targeted support. We've done the roadshow for the ATSI schools to make sure that we're considering those students and that that our special education staff, we've been encouraging that they should be included to make sure that they're getting that professional development. And we have our state systemic improvement plan is focused, and we focus on third grade achievement as a standard, but we use that to assess the progress that we're making and to develop and adjust strategies for improving reading proficiency, and we're continuing to work on that. We also develop training and tools to improve the delivery of specially designed instruction, to complement that general education instruction and promote the use of high quality instructional materials. And there'll be more of that to come, both webinars and various trainings that we do throughout the state. And of course, we have our SE teams that do both universal targeted and intensive TA for LEAs. And most notably for academics, we have our Academic Alliance and Skippy that are using your ELA and math performance to really help you target your areas of need and address those. And so that's some of the areas we're working on there. For as far as the other critical area of need of graduation and dropout, we're continuing to work on the South Carolina Pathways project, and that it's a pilot program to see if we can come up with methods and ways to improve the transition services and the different pathways that we have for students that would be helpful for students with disabilities. So we're going into year 3 of the we just started that in October of the 5-year grant. We're seeing some promising practices, and we intend to share those out as we see some successes on that. And so there's some pathways, some applications for innovative course pathways have been submitted to the Department of Education for approval. So our Office of Assessment and Standards are the ones who review those. So we're in the process of getting those through, and that'll be available as we get that. We're also working with a work group to develop criteria for academic seminar, and this is just to really, a lot of schools are already following criteria for a weight-bearing, credit-bearing course academic seminar at the high school level. Especially just making sure that we're providing specialized instruction, that it's not just a study hall for students with disabilities. There should be specialized instruction going on pursuant to the IEP for these students, and that's basically just setting a base foundational criteria for that. We're also going to provide support even above and beyond the Pathways project for supporting sequence applications for districts who aren't part of the pilot program but want to adopt some course sequence applications, which for blending those CTE requirements with the English and math required courses, so that students would have a different pathway to getting to the high school diploma. We'll continue to support the employability credentials. The numbers are growing. We expect them to kind of plateau, but they're getting up into that 10 to 15% range of students with disabilities who are on the path to get an employability credential. And there's continuing, the universal targeted and intensive technical assistance from SC teams, including dropout prevention and transition support from TASC. So we continue to put those in place. For mental health and student behavior, this seems to be a growing issue. We definitely are looking to see if we can partner with other state agencies to look for help, possibly from the legislature, to talk about ways that we can address this. Because we are seeing a need for evidence-based behavior programs in school districts, hopefully in the communities, is optimal. And so we need to work with you guys and with our partners around the state to try to pilot some programs. We're looking at the establishment of a high-cost fund as opposed to the financial aid reimbursement that we provide just for out-of-district placements. It would be a high-cost fund that could apply to any student that met a certain cost threshold. Other states have established it. It's typically done with state funds or state and federal funds, and so that's something that we likely need legislative support for, but it is something we're exploring. We're continuing to work on TA and IEP system adjustments that can help, looking at the FBA and the BIP and Ed Plan, and providing supports and tools based on best practices so that we can decrease that exclusionary discipline that we're seeing. We're also looking deeper into the different kinds of disciplinary actions that we're seeing throughout the state, and how we can address it at a systemic level. And we're also, of course, SC teams, particularly through BASC, is providing universal and targeted and intensive support to districts to try to address some of those behavior intervention needs and reduce the amount of exclusionary discipline that we see for students with disabilities. Teacher service provider, we continue to use SC Create as you saw from the data, we've significantly increased the number of participants in that program over the last 3 years. We're also we've partnered with the Cedar Center which other states have done and seen some good results, to develop a state recruitment and retention plan for special educators. In that process, we're looking at a lot of different things, financial assistance that we might be able to provide above and beyond CREATE to get more people in the profession. We're working hand in hand with the teacher preparation programs at the universities throughout South Carolina. We're looking at possibly modifying the teacher certification. Other states have gone to different ways of certifying teachers and different categories of certification for special education teachers, and if that would be something that would promote us getting and retaining more people. We're also looking at the requirements, the regulations around caseload, and whether we should switch to a workload model and what that would look like. And then examining teacher work satisfaction as well, and possible surveys to capture that information. And so those are the things that we're doing in collaboration with CEDAR. Some few other things we wanted to talk about. We had some recent releases, the online training tools training package. So this is there are tools in SE Ready and EOC in the digital application of it that are tools that can be used by students. Highlighters, ones that check answers or eliminate cross-out answers to help students work through the different problems in the assessments. And so those there are tutorials, there are lesson plans, there are things that we believe resource teachers can do to work with students to make sure they know how to use these tools, and so that they're ready on test day. So it's provided for you to give to your staff to use, so that they can do some practice with the students so that they're ready on test day. And that they're prepared and they can use some of these online or universal tools that are available through these assessments, in addition to the accommodations that they might receive pursuant to their IEP. And those should be tested and practiced as well in the general ed classroom, in their classrooms and in their instruction throughout the year. So that they're ready. The other one is that I know many of you are asking about the formative assessment data submission memo. It came out as a single memo. In other words, this was a general memo issued about formative assessments, and it does include instructions for those students that are on alternative standards. So it does include the links for this year, with the first submission being in December. So hopefully you saw that memo. It just went out as well. So I just want to make you aware of that. So some other things that we're working on an LMS course that would be, designed for teachers, particularly special ed teachers, on improving early literacy for students with disabilities. So that would be a recorded LMS course that they could take for those students. We're also working on, we know, and I hear it from you guys all the time, from special ed directors around the state, that some of these things, we need to get to other professionals, instructional leaders, school site administrators, superintendents. They need to know that in order to improve our special ed programs, we have to make some systemic changes. We really have to look at different things. And so we've been putting together some webinars, and we've been doing presentations when we can. I was recently at a chief instructional officer meeting. I went to SCASA as well, and just talking about some things that can be done to improve special education programs. And some are basic, like scheduling. You really need to account for special education in scheduling at all levels, elementary, middle, and high, to make sure that you're setting it up in a way that your students, like I said, can access that core curriculum and get that supplemental instruction that they need. And also to facilitate collaboration between general education teachers and special education teachers. We know that is the only thing that's going to move the needle, is if we align that specially designed instruction with the core curriculum instruction that they're getting. And that needs to have that collaboration time. And we've been surveying special ed teachers and general ed teachers for some time now, and we know that it happens in some places around the state, but it's not happening with the consistency that we would want to see. And we definitely want to improve that level of collaboration. And so we're working on approaching it to the people that need to hear about this. The other thing is exclusionary discipline, right? I mean, it's not usually within the hands of special educators as to whether the students are receiving suspensions and expulsions. And so we need to let school site administrators know that we have the highest rate in the country, that this is an area of need for us, and that we need to work on it. And that many of these students are not committing offenses that really warrant them to be excluded. And oftentimes when they do, it's going to be counterproductive. They're going to fall further behind, be more frustrated, and act out more. It also calls for the need for additional programs to address these needs. But these are some of the things, and I know it's many things that you've been talking to them about for years. But we're looking to expand this so that we reach these other audiences to make it clear that these are the areas that we need to look at, and that alignment between what instruction the students are receiving in general ed classrooms and what they're receiving in the resource rooms, to make sure they're aligned. We'll also be looking, like I said, we're working on the criteria, once again, emphasizing the need for specially designed instruction based on individual student need, all the way through the high school level in the academic seminar course, and making sure that they're getting high school content that is based, in part on ELA and math standards. Is for those areas of deficit that we should be working on the same standards that they're working on in the general ed classrooms. And then also, hopefully, within a year or so, we'll have a revised special education process guide as well. So those are the pieces we were working on. I've gone a little bit over, but I'll see if you have any questions at this point.
Peter,
A lot of
there are
information.
Yes, absolutely. Peter, there are several over in the chat, starting with Wendy Height. Do you want me to read them out, or can you see them okay?
I can see them.
Okay.
Let me see. All right. Is there an update on Part B funds becoming block grants? That's a really good question. No, not at this point. So there's competing budget bills right now. There's a Senate budget bill. There was a White House proposal as well. They're still in the proposal phase as far as the Part B funds. So the White House did call for block grants. The Senate proposal does not. So which one will win out, we don't know yet. Obviously, this kind of goes into all the budget negotiations that have been going on. So there's not a real clear picture. We're operating off of a continuing resolution. That's what was put in place. That the government ended the government shutdown was just a continuing resolution, and there's been a series of those. So we haven't really had a budget since 2024. At the federal level that was agreed upon by Congress. So they continue under these continuing resolutions. And so right now, it's still up in the air whether there comes to be an agreement or not. So we'll see what happens as far as, and it would be an overall budget bill for the Department of Education is where we'd see that. But I don't have any update currently. I mean, we expect that these negotiations will continue. But as soon as I hear about it, we'll let you know. Is there for the percentage of students with disabilities? I don't know for which one. We had a lot of percentages in there. So Wendy,
sorry, this is Monica. Can you hear me?
Yeah.
Okay. I wrote it right at the time, and then when I realized we were going to be asking you going over later, I was like, he ain't gonna know what I'm talking about. For exclusionary discipline, the state percentage, the target used to be 9%. And now I realize the state's gone up to 17.6. Is the state target still at 9%?
It is.
Okay.
Yeah.
Just wanted to be sure. Thank you.
Yep. 100%. You're right. Yeah. I mean, the goal is to bring it into single digits. And as you can see from that chart, many states have. Like it is doable. But that for this state, it's a pretty lofty goal, but yes, we've kept it the same. We haven't adjusted the state goal, which is 9%. Yep. Yes, absolutely. Susan said, based on the case, yeah, I mean, we need to make sure our students are reading and reading at grade level if we can, obviously if we can. The academic seminar, we had a productive meeting. We're working vigorously on that. And I know that some districts are worried about that. I mean, I can say this, that it's not a change. There won't be any new standards set in that criteria. The standards are the ELA and math standards for high school. So if you've been teaching to those standards, if they're providing instruction at those standards for ELA and math, then you can weight it. Ultimately, it will be up to the districts to select the weighting. We're looking at, there'll be an academic seminar, which will be a weighted based course, and then there's going to be an alternative for when you decide that the instruction being provided is not at the high school level. In other words, you're not providing instruction that's based on ELA or math standards at the high school level for those students. So we expect the criteria will be in the spring, but like I said, I think many of you, your courses that have been set up will meet the criteria, and you can select the weighted based for your course for next year. And so it shouldn't disrupt it. What it would call into question is if you're awarding credit on a weight bearing basis and those students aren't receiving any instruction in the classroom. If they're just getting accommodations for assessments or doing a study hall, then that wouldn't constitute specialized instruction. But if you're providing grade level assistance to these students based on individual need, then you can continue to award a class with weight and credit. All right. So I think there was a clarification of the percentage. Overall percentage of students with disabilities in the state. That is based on, it's gonna be based on mandatory age, because it's looking at the percentages based on the overall student population versus the percentage, the number of students with disability or students who have been identified under the IDA and have IEP services. So it might include, actually, Carolyn, would it include that percentage? It would include anybody enrolled in 3K and 4K, whether they have an IEP or not, but it's not obviously universal. But I think it's all students would be the denominator, all students enrolled in school in South Carolina in whatever program they're enrolled in, and then the total number of students with the 114,000, the total number of students that we have that are ages 3 to 21 with IEPs.
For the discipline?
No, for our overall percentage. The
Oh, yes,
15,
it's the total.
15%.
Yeah, it's the total number of kids enrolled in your district, ages 3 to 21.
Right.
All
And
enrollment, all enrollment,
right.
divided by the child count.
All right. I know we have some SC team stuff.
Yes, we do. And we've been, with Jenny's help, been texting them. There is one last question here, Peter, from Elizabeth. Are the students with disabilities who are not enrolled with us counted in our total enrollment number, or does that come straight from the 45-day count?
Well, we use child count for that number, not the 45 days. We use the child count for our students with disabilities. We do have to turn in the number of PPSC students that have been identified under the IDA as well.
Okay, thank you. I will share my screen because there's just a couple of slides that SC teams asked that I bring everyone's attention to. And then just a reminder to please, all right, come on. Just make sure you look through the slides so that you see all the rest of them, but I'm just 2 slides in particular I hope I'm going to share with you. Come on, there you go. Is this series on explicit instruction, the Explicit Instruction Academy information sessions. So if you'd please take a look at that, that is slide number 44. Ask has some other things on here too, but that in particular they wanted me to bring to your attention. And SC Case sent in a slide. They wanted to give you a heads up so you could save the date that their pre-conference event for CEC. I said that right, yes. Anyway, pre-conference event from SC Case is going to be February 26th, and that information is in there, the cost, links, QR codes, all kinds of things. And of course, there's other things from Skippy and so forth. So please be sure you take a look at the rest of your slides. And as always, if you have any questions, feel free to reach out and I will find somebody to answer your question. And thank you very much for your time today. Have a great evening.